See, I talk about what a good baker I am and what a good cook I am, but it's great in interviews because nobody's actually trying your food, so they can't really fact check it.
Oh my God! Wow!
You know what happens when someone's facts don't hold up? They double down on feelings. And right now, Blake Lively's entire legal strategy is emotional bait without the hook. So if this isn't about evidence, and it's definitely not about law, is Blake just here for the aesthetic? Let's talk about what just happened. After months of Blake throwing legal glitter in every direction, subpoenas to YouTube creators, threats disguised as pleadings, and motions that read like brand management memos, the defense dropped a reply that calmly, ruthlessly dismantled the show. Not with drama, with details. And unlike her filings, this one doesn't scream, it just cuts. So here's the play. Blake asked the court to punish the people she's suing using California's Civil Code 47.1, a law designed to protect survivors from defamation. Not only does Blake not live in California, but none of the conduct she's complaining about happened there either. Everything went down in New York and New Jersey. The defense walked the court through the basics. California law doesn't apply. That statute doesn't travel. Even if it did, she'd need to prove she spoke without malice and with a reasonable basis. And no one, not a judge, not a jury, has found that. She's trying to claim protections before facts have even been settled, like trying to pick up your Oscar while the script's still in rewrites. Oh, and those damages she wants? Treble, punitive, all those big dollar words. The problem with that is there's no actual damages to multiply. You can't triple zero. This isn't algebra, it's a tantrum in legal format, and the court knows it. She's leaning on a law that doesn't apply, demanding damages she hasn't earned, and spinning legal defeats as moral wins. That earlier defamation dismissal she clings to like a merit badge? It wasn't because the court thought the other side was wrong. It was because their statements were protected speech, privileged, boring, not dramatic enough for Blake's narrative, so she rewrote it. And the defense noticed. They said it straight. This motion looks like a PR stunt dressed up in legalese. A thinly veiled effort to poison public perception and the potential jury pool. Translation: this isn't law, it's branding, and they're not buying it. This is the part where most people would pause. But Blake keeps filing. She keeps spinning. Every time something flops, she pivots. When the narrative sags, she throws another filing at the wall. It's like watching someone audition for victimhood with no script, no receipts, and no exit strategy. Here's what really stands out: the people she's aiming at. Not the reporters with platforms, not the anchors with syndicated reach, but creators with day jobs and microphones. Women who can't drop 10 grand on legal fees just to respond. If this case were solid, she'd be going toe-to-toe with the big voices. But she's not. She's swinging sideways, picking soft targets, sending the message, criticize me and I'll make it expensive. That's not justice. That's intimidation with a gloss filter. And while she's doing that, the defense is playing it boring. Dry filings, careful footnotes, no press tours, no captions, just law. That's how you know who's actually ready to be under oath. People ask if this is going to trial. Maybe. People ask if she'll win. Define win. Because if your strongest move is a statute that doesn't even reach the state you're in, and your biggest threat is tripling imaginary damages, what exactly are you hoping to walk away with? A judgment? Or just another photo op where you're cast as the wronged woman walking bravely into the light?
Allegedly, that's ignorant.
I'll say it. This doesn't look like someone seeking resolution. It looks like someone stalling for the next narrative beat. Her filings have rhythms, swells, climaxes, like they're written with PR timing in mind. And every time the real facts start to settle, a new document lands like a smoke bomb. You don't need a legal background to smell the deflection. You just need pattern recognition. Because what Blake's doing, it's the influencer version of litigation. Keep the buzz alive, control the frame, weaponize timing, and pray the audience is too distracted to read the footnotes. Except this time, the audience isn't blinking. Every filing gets posted, every motion gets analyzed, every receipt gets pulled apart and lined up like a timeline. The story she's trying to tell doesn't match the one playing out in the docket. And no matter how many times she tries to cast herself as the hero, the script keeps slipping. The defense didn't just clap back, they held up a mirror. They showed the court and everyone watching that what's happening here isn't about safety or protection. It's about control. It's about managing optics. It's about using the courtroom like a ring light. This is what it looks like when someone tries to launder a weak case through strong headlines. Blake wants immunity before discovery. She wants damages before evidence. She wants the trophy before the game starts. And now that someone finally said no, we're watching her spiral in real time. You can file motions like Instagram posts. You can weaponize subpoenas like DMs. But at some point, the filter peels off, and the court and jury doesn't care about your follower count. What they care about is jurisdiction, proof, process, all the boring stuff Blake's filings keep trying to swerve around. So what happens now? She either drops it or she doubles down. If she doubles down, the questions get harder, the scrutiny gets sharper, and the next time she files, the court's going to be reading between the lines. Because the moment your story needs a legal loophole to survive, it's not a story, it's a script. And Blake? She's already on take 20. The mask is cracking, the curtain's twitching, and for the first time since she started this, it's not her voice that's filling the room. It's the echo of every question she didn't want to answer. And let's not pretend this is brave. It's exhausting. It's the energy of someone who wants to look like they're fighting without actually stepping into the ring. Every filing is a press release in disguise. Every quote is crafted for sympathy, and every time someone checks the facts, they're met with motion sickness from the narrative spinning in circles. If this strategy had a face, it would be a tight-lipped smirk on a red carpet, pretending not to see the reporters shouting questions. She's trying to run the courtroom like a brand partnership. Like, if she just keeps her aesthetic intact, the legal mess won't smudge the campaign. But the court doesn't care about tone palettes or lighting filters. They care about facts. They care about law, and they're watching her try to swap out evidence for engagement. Eventually, the filings run out. The hashtags stop trending, and what you're left with is a judge asking one very boring, very dangerous question. Where is your proof? Because there's one thing Blake hasn't filed yet, an honest answer. And while we're here, let's not ignore the math. For all the talk about triple this and punitive that, the only thing multiplying is the drama. The actual damages, still missing in action. You don't get to cash in on imaginary pain and expect real compensation. This isn't a screenplay. This is discovery. At some point, even the judge is going to raise an eyebrow. Because this isn't just an argument falling apart, it's an entire strategy collapsing under the weight of its own press clippings. You can't stack magazine covers into a motion and hope it lands. This is the legal version of yelling, "I'm being attacked," while throwing champagne flutes at the wall. Loud doesn't equal right, and the louder it gets, the easier it is to hear what's missing: the truth.